Hello, this is John Milburn for Laws 12060. This is trusts. We're into week 7, and this week we're talking about objects of a trust, or beneficiaries, if you like. The prescribed reading is chapters 21 and 27 of Radden and Stewart, but I think chapter 27 is probably the more important of the reading. Speaking of reading, you are supposed to keep ahead of the reading. I hope you're doing that, or at least attempting to do that. Now, I'm being told that people can't hear me. Is that right? Can't hear me? All right. All right. Okay. People can hear me? Excellent. Thank you. Thank you for those that have joined us live tonight. We appreciate that. And last week we talked about the duties, the powers, and the rights of trustees. So this week we're considering the same issues, but from the perspective of the object, which is the beneficiary or the beneficiaries. Before we get into tonight's topic, I just want to digress for a moment. And those of you who have worked with me in the past will know that I'm pretty fussy when it comes to the way in which you present your assessment work. Now, I'll change that. I'm very fussy. And you've probably heard me say this in the past, that if you're in practice as a lawyer and you're charging, say, $400 an hour, you really must produce a product that looks the part. So make sure that your document has a professional look about it. It might be a little understated perhaps, but it can still be inventive. You can still use flowcharts or things of that nature if you want to. Make sure that you reference appropriately. I'm really keen on referencing. I want you to firstly acknowledge the source of work that is not yours. You can use it, but reference the material, and do so by using footnotes. If you're not familiar with the Australian Guide to Legal Citations, please take a moment to do so. Have a look at the AGCL, and you'll see at the back of the AGCL, there's a really handy reckoner to make it easy to refer to the documents. And if you want some guidance as to how to reference in accordance with AGCL, have a look at cases and have a look at your textbook, and you'll see that the format is essentially laid out for you. So learn through osmosis in terms of how to present the footnote material that you present in your assessment work. So I do expect a certain standard. And of course, when you present something that looks professional, you inspire confidence in the reader. And I'm not immune to that. So if it has a professional look, if it's presented the way I want, which doesn't have to be, like in a manner that I like, I should describe, doesn't have to be exactly the way I do it, but it's professional and it's footnote referenced appropriately, then you're on the right track. A couple of things about referencing. Make sure that with your cases and your legislation, you type it in italics, not the reference itself for the case, but the names of the parties is in italics when you're referring to a case. Make sure that you're aware of when you use round brackets and when you use square brackets. I know this is introduction to law stuff, but please have a look out for that. Make sure you get it right. Also, have a look at pinpoint referencing and make sure that if you're referring to a page, you do so by appropriate pinpoint referencing. So Dietrich against R, open round brackets, 1992, close round brackets, 177 CLR 292, 299. That gives me the citation, and it tells me that the pinpoint reference for that case is at page 299. Okay, so that's what we want to see in terms of assessment work. Are there any questions about the assessment or the presentation of the assessment or AGCL or footnote referencing? We should all know that by now. All good? You can unmute your microphone or you can use the chat facility as you see fit. Okay, so tonight's session, some preliminary questions I'd like you to ask yourself. Firstly, who can become a beneficiary? Secondly, what is the nature of beneficial rights? Third, what are the rights of a beneficiary? And what personal remedies are available to a beneficiary who alleges a trustee has breached a trust? These are all good questions to ask yourself and have answers to as part of your exam preparation. So who can become a beneficiary? What's the nature of beneficial rights? What are the rights of a beneficiary? And what personal remedies are available to a beneficiary who alleges a trustee has breached a trust? Remember, of course, the three certainties. Right back in week 1 and week 2, we talked about the requirement for an express trust to have the three certainties. Can you remember what they are? Just a bit of a refresher to warm you up. What are the three certainties? You can unmute or you can use the chat facility. Three certainties of an
certainty of intention.
Yes, very good. Thank you. Thank you, Peter.
Certainty of subject.
Yes, very good. And the third one, object. Yes, we're getting some answers there.
Certainty of object.
Yes, that's it. So what do we mean by object? What's an object?
The beneficiary, who holds the beneficial right.
Thanks, Melissa. Yep, that's it. I don't know why we say object, but it's really a beneficiary. And what's important about having a beneficiary in the context of enforcing a trust obligation? It's a very practical reason.
If there's no beneficiary, there's no right to be enforced.
Exactly. Yeah, it's kind of a chicken and the egg argument. If we don't have a beneficiary, we've got nothing to enforce. There's nothing to enforce if we don't have a beneficiary. So it goes around in circles a bit. Remember the statement from 1804 in Maurice and Bishop of Durham, and that was Sir William Grant established that principle. So in that case, essentially what the court said is every trust must have a definite object, that's a beneficiary, who can enforce the trust. And the court doesn't take the initiative to enforce trusts. There must be someone to bring it to the trust's or the court's attention. So we mentioned that last week. So tonight we're looking at these issues to do with enforcement primarily from the perspective of the beneficiary. So this subject ties in with equity, of course. So when we talk about someone having a beneficial interest, we're talking about an equitable interest. I guess we're all on top of that. We know that. We know that the beneficial interest, which is equitable, can be fixed or discretionary. We know that. And we know that if it's discretionary, a potential beneficiary can be part of a closed class or an open class. What do I mean by that? A closed class or an open class of beneficiaries?
Closed class is specific. They give you specifically who they are. Open, it is general. It can be like to all my living relatives or
yes,
something general.
Yeah, and I think that's a really good way of explaining it. To my mind, it's really an issue of extent. And there might be some grey areas as to whether it's closed or open, but that's essentially it. If it's closed, it can't be expanded on in the future. It's fixed in terms of the people that are to be the beneficiaries. Whereas if it's an open class, potentially, you know, there might be grandchildren who come along at a later time. So when we're talking about a beneficial interest, the courts have said that there is a difference between beneficiaries and their ability to enforce a trust. In essence, the stronger the equitable interest that the beneficiary has, then the more rights they have to pursue issues in relation to enforcing trust obligations. So if you are merely a potential beneficiary that has a hope or maybe even an expectation of receiving a benefit, your entitlement to enforce the trust is lesser, it's different to those who have a fixed interest, particularly those who have a fixed interest in a closed trust, or they're in a closed class of beneficiaries. One thing that I talk about in Introduction to Law, I guess a lot, apart from being, you know, ramming it down their throat to make sure your document looks right, is I talk about brainstorming. Those of you who've worked with me in the past would have heard me say that. And the reason I say that is that we need to be careful about other areas of practice, other ways of doing things that might be relevant. So just because we're studying trusts, it doesn't mean that we should be blind to other areas of practice that may have a bearing on what we're doing here. So in the context of enforcing beneficial rights in a trust, can you think of other areas of practice that may have a bearing on the way in which we look at legislation and we look at the jurisdiction and we look at the enforcement? And of course, as always, I've got a particular answer in mind, but I'm sure you'll come up with something else. So what other area of practice?
Are you referring to interpretation?
Could be, yep.
Yep.
Sorry, Peter. I'll let you finish.
Yeah, sorry. I was just going to say, are you referring to statutory interpretation?
Could be. Statutory interpretation is always really important. And Eustace, you came up with the answer I was looking for, the Family Law Act. But it doesn't have to be just issues of statutory interpretation or the Family Law Act. There can be other situations where the trust law is supplemented by other information. So we see a lot of trust law in family disputes, don't we? We see a lot of people that even were married who are involved in trusts. We see people that were in a relationship which is committed but not a marriage situation. And both those, of course, now we have the Family Law Act that can apply. Can you tell me, and I know this is off topic, sort of, but what are the sections of the Family Law Act that we need to consider, be mindful of, when we're talking about the way in which beneficiaries can enforce a trust in a family law context? So a couple of very well-known sections of the Family Law Act have a bearing on the breakdown of property rights in a marriage situation or a de facto property settlement. So I'm looking for some numbers. What are the section numbers? Family Law Act? If you haven't done family law...
John,
yes, Linda?
I've looked at section 79.4 because you mentioned that one in your notes.
Yes.
And that in the consideration of property settlement and how the court, in what order the court will look at to determine who gets what, I suppose, like financial contribution, you know, is it made directly, indirectly, and it just outlines all of these points down to G.
Spot on. That's excellent. It's not the only one, but it's one of the two very important sections in the Family Law Act that deal with the factors considered by a court when determining the distribution of property. I see Brad's ready to go. What's the other one, Brad?
Sorry about that. Yeah, 75.2, section 90 MC, super splitting, and there's probably a few others in there.
Yes.
But they're the main ones.
They are. Melissa has added, Grant has said 79.4 and 75.2. So that reflects what Linda and Brad said. Thank you. Brad said 75.2. Sophie said 4. Melissa said 90 SM and 90 SF. So for de facto relationships. So why on earth, in the context of trust law, am I talking to you about the Family Law Act? What's that got to do with the price of eggs?
Is it determining who will be the beneficiaries? Does it have a bearing onto that? But wouldn't that be how they write the trust, wouldn't it?
Yes. It'll not so much who will be the beneficiaries, but who will obtain a beneficial interest. And yes, the strict terms of the trust can, in a sense, be altered by the statutory provisions of the Family Law Act. I shouldn't be giving away answers here. Does anyone have any other thoughts as to why I'm talking about the Family Law Act? Brad says, just an equitable distribution of property. That's a really good phrase to keep up your sleeve when you're considering trust law. Do you want to elaborate on that?
Well, one of the four elements of the 79.4, the final one, the just and equitable distribution, is essentially the governing rule that the courts attribute as to whether a settlement fits within the range as expected under the equitable distributions of their property.
Yes. So I guess the point that I'm making is this, that if we look at trust law, particularly common law, in isolation, without thinking about these other areas of practice and without thinking about statutes that may have a bearing on trust law, we may actually come up with the wrong answer. I mean that in the sense that if we have people that are in a particular relationship, then the overriding provisions of, say, the Family Law Act may apply to substantially alter the way that the trust is considered from the perspective of the beneficiaries. Brad was right. We look at the just and equitable distribution of property in accordance with the Family Law Act. And what that means is that if you're consulted by a client in a family dispute situation, you can't necessarily just look at the trust instrument, just look at the Trusts Act and apply the common law as if it's a pure trusts problem. There's this bigger, I'll call it cloud, there's this bigger cloud that overhangs that area of practice. So be mindful of that, and the Family Law Act is a really important one. And it comes down to this in section 75(2), amongst other things, the court is totally entitled to take into account income, property and financial resources of each of the parties. And a financial resource may well be an interest in a trust. So just keep that in mind. Also have a look at section 85A of the Family Law Act, which deals with property settlements, prenups and antenups. Okay. Thank you for that. We can see how what I'm trying to say works in practice by looking at a High Court case of Kennan and Spry. It's 2008, 238 CLR at 366. Can anyone tell me what Kennan and Spry was all about? Who were the players in that case? It's an important case. We'll get you started. It might come back to you when I say this. So Dr. Spry was a retired barrister, Queen's Counsel in Victoria. He was married to Mrs. Helen Spry, and they married in 78. They were separated in 2001, and they had 4 daughters from the marriage. Now, Dr. Spry had set up some trusts, and right back in 68, he set up a discretionary trust. It was varied a few times. And one of the variations in 1983 was to exclude Dr. Spry himself as a beneficiary and appoint Mrs. Spry as trustee upon Dr. Spry's death or resignation, and the eldest daughter as trustee upon Mrs. Spry's death or resignation. So we had this marriage situation which predates the Family Law Act of 1975, which was in the sense that the trust predates that. The marriage occurred in 78, so that's after the Family Law Act, and the separation certainly occurred within the context of the Family Law Act. Anyway, there were difficulties in the marriage, got pretty nasty actually, and the trust deed was varied. In 1998, I guess perhaps at that stage they were starting to experience difficulties in the marriage. They separated in 2001. Dr. Spry changed the trust again and excluded himself and Mrs. Spry as beneficiaries. Anyway, they did separate in 2001, and in the following year, 2002, following their separation, the trust was changed again really substantially in that it was split into 4 different trusts, one for each of the daughters. And Dr. Spry and a friend, Mr. Kennan, were joint trustees. So now we have the Kennan and the Spry. They're joint trustees of these 4 separate trusts. And we're not talking small amounts either. Anyway, so that was the background to the situation. And the question was whether those trust assets could fall within the definition of property for the purposes of family law proceedings, because the argument was at that time a party could not assert any legal or equitable right in relation to them. That is, a party to the marriage, bearing in mind, of course, that Dr. Spry had split those trusts up. In most cases, where the trust asset is purely based on a discretion or a mere expectation and not a financial resource, there are issues that don't come into play. Anyway, the matter went all the way through to the High Court. And ultimately, the High Court said that the trust assets were, in fact, property of the marriage, even though the trust had been amended to the point where Dr. Spry was not a beneficiary, Mrs. Spry was not a beneficiary. There were now 4 separate trusts for the children. So the court essentially overturned the amendments and effectively reversed those 4 trusts, which were nominated eventually for the benefit of the Spry children. So going back to a comment made by Brad, which I said I really liked, the just and equitable distribution of property, Brad said, we can see how the High Court in Kennan and Spry had a look at pure trust law and said, we don't like it. We don't like what's happened here. We are essentially going to unravel all this. Dr. Spry's good work was overturned as a result of the decision. And the basis for doing so was we have the statutory provisions of the Family Law Act that will override and give power to the court to essentially go behind all of these trusts and on a just and equitable distribution of property perspective and deal with them as though they are a financial resource of the parties. Have a look at our now Chief Justice Kiefel, just as she was at the time, Justice Kiefel of the High Court, who said, referring to Section 85A, which I mentioned about the antenuptial and postnuptial settlements, said it's intended to have a wide operation, that the property be held for the benefit of the parties on the settlement to which they've contributed, and Her Honour applied that section even though on the facts the beneficiaries were the children. Okay, so the High Court really did make intrusions into what was previously perceived to be a great value of trusts in terms of being able to, I think hide is probably the right term, assets from, in this case, the partner, the husband or the wife or the former partner. So that's where we started to see the Family Law Act interpreted in such a way that trusts really, we didn't really mind or care who was the named beneficiary. We look at this just and equitable distribution. So keep that in mind if you're dealing with a question that relates to the relationship breakdown of people that were married or in a de facto relationship. Now, I've done a lot of talking there. Are there any questions about Kennan and Spry? Yes, Brad?
I just had a look at the snapshot on that, and there's been a lot of cases that are relied upon that of recent times. And my observation, correct me if I'm wrong, is essentially what they've done is they've looked at where the origins of the contributions were, which were resources of the marriage, which were contributed to the trust. And when he's unravelled the first trust, essentially he's re-established the trust to the detriment of the existing beneficiary. So there's sort of issues there with stamp duties and how they look at that, as opposed to how we see some of the European origins where mum and dad are the trustees of all these assets, and when they're being challenged, it's, well, who actually controls the trust, what were the origins of the funds, etc. So the Family Law Act and the courts will protect that type of trust, as opposed to what Mr. Spry has tried to do, is to divest the matrimonial pool by moving funds from the matrimonial pool into trusts of which he alleges he did not control through Mr. Keenan, which I'd find hard to believe.
No, I think some really good points there. I won't make any comment about the European law in relation to it, but I think you.
No, I mean European families that live in Australia.
Oh, I'm with you. I'm with you. All right. Yes, where there's that patriarchal or matriarchal approach to trusts. Yes, I think it's fair to say that the Family Law Act is now interpreted in such a way that the pure technicality of control and beneficial interest in trusts is now pushed aside where it can be in favour of a more global approach where we look at a distribution of those sorts of assets as financial resources and then make the just and equitable distribution of property. So those of you doing family law will know that the first step is to try and identify the pool. And what we're really saying here is that the pool can include these trusts even though there is not technically control or technically benefit. And we rely on Kennan and Spry as it's been adopted, as Brad said often, in that case. Right, any other questions or comments about the Family Law Act and Kennan and Spry?
Yeah, sorry, John, just asking about the...
Yes, Grant, we'll go with Grant first.
Asking, in the book, I'm just confused where it says the High Court dealt with these issues in Kennan and Spry, where Dr. Spry, the husband, had created a discretionary trust for all of the issue of his father and their spouses. Both he and his wife were among the beneficiaries. So the trust wasn't actually his money anyway, from the way I read that. He's received money from another trust anyway, and he just made his wife the beneficiary of it.
Yeah, that's probably the amendment in 1998, I think. Whereas the trust was amended and split up a lot. So bear in mind that after they separated in 2002, Dr. Spry then created these 4 separate trusts and essentially had nothing to do with them. But there were different iterations of this trust on the way through. Tamara, did you have some comment?
I was just going to say, just sort of going off what sort of Brad and everyone else has sort of been saying, so it's probably already been answered, but is it also sort of like the courts like recognising that sort of trusts are there for a reason, and there's, you know, sort of legislation and case law that's, you know, sort of makes them what they are and operate as they do, but sort of respecting that, but also saying there's a reason for them, there's a reason why they work, don't abuse it. So if you've got sort of trusts set up within a family, you know, sort of don't use them to try and diddle your partner out of, you know, a heap load of money or assets, or however you want to say it.
Yeah, and I think that's a fair comment. I think what we need to be a little careful about applying Kennan and Spry in every circumstance, because the facts in that case were a little particular in that it was quite clear to the court, at least, that Dr. Spry was trying to unravel these trusts and essentially keep the money, keep the assets in those trusts away from the matrimonial pool. But they started in the matrimonial pool, and the effective result of the High Court decision was to reverse the various amendments that led it to the stage where the trusts were held for the children. Now, that's an entirely different situation to a trust that is established by parents for the benefit of a child or children in circumstances where their intent from the outset was to benefit the children. Now, in those circumstances, if it can be factually established that the funds were provided for the children and have been maintained in a trust for the children, then I believe it's unlikely the court would try to unravel that trust and incorporate those assets as part of the financial resources between the parties. Now, was there someone else wanted to make a comment? Was it B? I'm not sure. No? Okay. All right. So,
sorry. Anyway, since you mentioned it,
yes,
since you mentioned it, I think it was one of the questions whether, you know, the creators of such a trust for their children could decide that the children were near the wells and wanted to kick them off, you know, close down the trust. Probably like Gina Reinhardt, you know, decide that the kids were hopeless and want to disinherit them. Can they do so?
I'm glad you answered. I'm glad you asked that question, because look, it's a while since I've written the exam, but it might be a good exam tip to know something about how parties, parents, might try to unravel circumstances where trusts set up for the benefit of children are not going to likely fulfill at least their purpose or their intention in situations where the child or children have gone off the rails and are maybe looking to use those funds for a purpose which was not the intention of the parents. So just keep that in mind. So thank you, B, for raising that issue. All right, so we've talked about the possible intrusion of the Family Law Act, Commonwealth, in the way in which we look at trusts from a purely academic trusts perspective. Can anyone think of, I've got one other act. Oh, sorry, Brad wants to ask about Section 61 of the Trusts Act. Would you like to do that now, Brad?
Yeah, it was just, I was catching up on week 6, since I read week 7 last week, and you talk about the powers and maintenance of advancement. And said Section 61(1) talks about setting up, may apply for towards the infant's maintenance education, in brackets, including past maintenance or education. Can you suggest a case that may point to that, or just I do an advanced search to see a case that applied 61(1) of the Trusts Act? No.
You're on mute, John.
You're on mute.
Sorry.
Sorry, John, you're on mute.
Yeah, thanks, Brad. I'm interested in that because if I was given that task, there's a certain way that I would go about doing some preliminary quick research. So I'm just going to share the screen. Hopefully this will work and we can see if... Can you see that screen now? Oh, I'll get rid of it.
Yep.
I tell you, I'm seriously going to buy a few more monitors. So if I was doing some research on Section 61 of the Trusts Act, it's not authorised, but I would go to OSLI, I'd look at Queensland cases and legislation, I'd go to Queensland Acts, I'd go to the Trusts Act. Now, I haven't been through this exercise, so this is purely spec. Brad, I don't know if this is a work or not. I'd then go down to Section 61, and which is the power to apply income for maintenance, etc., to accumulate. And I would then go to this feature here, Note Up. I'm sure you all know Note Up.
Yep.
Note Up is great, and I would then see if there's any case law in relation to it. And generally, you go for the case that is most recent and comes from the highest source. So we've got one here from QLRC, the Family Court, Federal Court of Australia, rather. So that's the way I would do the research, and there's one there on Family Court. I'll just stop.
No, thanks for that.
All right, thank you.
I was interested when I read it because I do a bit of setting up of CMT, so I was interested in. But I'll have a look at those cases tonight. Thanks for that.
No, that's all right. Thank you. So does anyone else have any comments about their research methods? I'm interested because I want to know what you do. Do you go to Jade Barnett, or do you go to Westlaw, or do you go to LexisNexis? Or any thoughts? Where's your first point of call? No? Textbooks. Some of you might go to textbooks. All right.
I like Jade Barnett.
Yeah, it's great, isn't it?
You don't always get everything on Jade Barnett, so
Linda, have you subscribed to Jade Barnett to get the daily updates of material?
Not yet, no.
It's a great idea. It's a great resource. Just go on, subscribe to Jade Barnett, and you'll get in your inbox up-to-date case law relevant to your area of interest. Great for an exam. Could you imagine walking into a trust exam and quoting a decision of the High Court that was put down last week? Wouldn't that be terrific? All right. So getting that up-to-date resource to your inbox is a great way to do it. Note Up, says Melissa. Yep. Now, what other piece of Commonwealth legislation might be relevant when considering the manner in which trusts operate in practice? And I think your spelling is right there, Brad. Social Security Act. Thank you, Grant. That's the one I was after. So Social Security Act overturns that traditional view that assets held on a discretionary trust should not be factored into assets for means testing purposes. So trusts were very popular in the 70s when I first started to practice to study law, and in the very early 80s when I started to practice in law. But we noticed during the 80s, the 90s, and then so on, particularly the amendments to the Social Security Act in 2002, that there are great intrusions now into the way that people can use trusts as a way of securing ongoing social security benefits. So again, a little bit like the approach of the Family Law Court and Federal Circuit Court when applying the Family Law Act. Now, because of, have a look at sections 1207V through to 1208 of the Social Security Act 1991, which incorporates those amendments in 2002, you'll see that there is wide power now to incorporate these discretionary trust assets into what are effectively the assets or potential assets. And Brad says, big push on special disability trusts. Okay, I'm not an expert on that by any means, Brad, but keep that in mind as well. Thank you. So these statutory provisions can really upset the theoretical answer that you might provide for a trust's problem. Keep it in mind. All right, so going back to basics then, we know that the trustee is the legal owner of property. The beneficiaries are the equitable owners of the property. That's simple, we know that. And it means that the beneficiaries can terminate the trust and pay over their respective interests under the trust through extinguishing the trust in appropriate circumstances. So what's the basic rule that allows for beneficiaries to terminate a trust? It's the name of a case, an old case. Can you remember it?
The rule of Saunders.
That's it. Thank you, Angela. Saunders and Vautier. Okay, that's it. B's got it as well. So just know about that one, and you see it a lot. What's the difference? And I'm going to ask a general question. What's the difference between a proprietary interest and a personal interest in the context of a beneficiary making a claim? What do we mean by proprietary interest?
Does a proprietary interest mean that you've got like a better interest in the property and that it can be sued on and whatnot? So if you pass it on to someone else and they can sue on that, but if it's a personal interest, it's personal to you only and you can't pass those sorts of rights on?
Yeah, I think that's a really good approach. I think that's a really good answer. So when we're talking about propriety, think of property. So it's actual property. And if you have a unit in a unit trust, I think it's fair to say that you have a proprietary interest in the trust assets. Whereas if you are personal, then, and Justice says personal money, proprietary property, yep, that's another way of looking at it as well. If you have a personal interest only, then you have the right to seek certain recourse to the courts, particularly in terms of compelling a trustee to do their job, but you don't necessarily have a right to claim an interest in property. A little bit like shares, in the sense that if you have shares in a company, in BHP, you have a proprietary interest in the shares, but you don't necessarily have a proprietary interest in the individual assets of the company. In other words, as a shareholder, you can't say, well, I don't want you to sell that mine because I own part of it. You need my consent. Your interest is different. Your proprietary interest is different to the property which is held in the company. So that's a real stretch, that analogy. So be careful with that, but that's a stretch.
John,
Yes, Brad.
in Saunders and Vautier, is it essentially because he was the only beneficiary, so unanimously he voted to wind up that trust because he was of age?
I honestly can't remember the facts whether it was only one beneficiary, but if there was just the one beneficiary, yes, that makes it easy. The beneficiary was sui juris, had the beneficial interest, didn't need the consent of others, obviously, because there was no other beneficiaries. But I think that principle, correct me if I'm wrong, but I think the principle applies more generally, that if you have a number of beneficiaries, then that principle in Saunders and Vautier will mean that collectively the beneficiaries can call upon the trust to be wound up, terminated, and the funds transferred. But that really doesn't work where you've got a discretionary trust situation. Okay. So the beneficiaries' rights come about through common law, but they also come about through legislation. I won't ask again. We know we go to the Trusts Act in order to determine the legislation. Beneficiaries have a right to information, don't they? They're entitled to information about the trust property. They're entitled in certain circumstances to inspect issues to do with the trust and the operation of the trust. And that makes perfect sense, doesn't it? When you come back to the principle that we said at the start, and that is that it's up to the beneficiaries to seek to enforce the terms of the trust. How can they do that if they don't have access to the information and access to the way in which the trustee is going about his or her or its job? So the beneficiaries are entitled to be reasonably informed about the workings of the trust. And this is where I come back to an earlier point about the extent to which the beneficiaries are entitled to obtain that. So if you have a discretionary trust and you have a remote beneficiary, one that really realistically isn't going to receive a benefit, but is there technically may be able to, then that mere potential beneficiary is less likely to be given access to information to the extent that would be the case if you have a much more direct beneficiary. That sort of comes back to that point that I made at the start about not all beneficiaries are essentially the same. But sometimes trustees in a discretionary trust situation make decisions which is based on their discretion. So the question then becomes, to what extent, if at all, do beneficiaries have a right to reasons by a trustee in terms of a decision to distribute funds in a discretionary trust in a certain way? Do the beneficiaries have right to call upon the trustee to give reasons?
I think I read somewhere along the lines that it's pretty much too onerous to expect that of a trustee in the case of a beneficiary, of a discretionary trust. Otherwise, they'd have people pretty much nagging them all the time.
I think that's right. And I think B came in with an answer saying no, and I agree with both of what you've said there, B and Angela. So generally speaking, the trustee is not obliged to give reasons for a decision. Do have a look at Section 8 of the Trusts Act. It provides for beneficiaries that might be aggrieved as a result of an exercise to apply to a court to review, but through that process, the court may call upon the trustee to give reasons. But to be honest, I haven't used Note Up on Section 8 of the Trusts Act. It's not something that readily comes to mind as a section that I've heard of being used in many circumstances. Just some comments. B says, but if they do give reasons, they can be found to be unreasonable. Hartigan against nominees. Yeah, Hartigan nominees against Ridge is a 1992 decision in New South Wales. It's 29 NSWLR 405. And that's right. So if they do give the information, then it is something that can be attacked in those circumstances. Brad says Rule 648 of the Uniform Civil Procedure Rules. I haven't got my UCPR handy, Brad. What's 648 all about?
Well, it's only because I had to write a letter about it today, so I looked at it. It's the obligation of the trustee to show accounting on the administration of the trust. So distributions, who it's gone to, that, you know, the assets that are held by the trust, dividends, all that sort of thing.
Very good.
So
And
it was interesting reading.
I really like that because that's tying in these other areas, you know, this sort of brainstorming type approach and looking outside the box. So a trustee can decline to give certain information to beneficiaries. There may be reasons to do that. In Rouse against IOOF Australia Trustees, which is a South Australian decision, the beneficiary was involved in a legal dispute with the trustees, and it sought access to the brief to counsel between the parties. So that's an example of where they may be very specific about trying to get information. And also have a look at Smith against Rosewood Trust. It's an English case from 2003. The Privy Council advanced a discretionary approach to the beneficiary's access to trust information. Okay. Look, I think we should probably just, I'm running a bit out of time, but do have a look at flowchart 7.0. I won't bring it up on the screen. You probably should have it there, and you'll see, actually I will bring it up on the screen. If you can bear with me while I do this.
Well, while you're doing it, I thought that Section 8 only meant that you could apply to the court to review the trust only if you're alleging a breach of trust, but you couldn't actually say, oh, they've been unreasonable in not giving me money.
Yeah, and I agree with that, B. So if it's a beneficiary in a discretionary trust who's disappointed not to have been the recipient of funds, then realistically, you don't have the opportunity to go to court. But if the trustee has breached the terms of the trust by, for example, not making a decision within the timeframes contained in the trust, then by all means, Section 8, really handy section to note, Section 8 is something that will allow the beneficiary to go to court to seek an order to compel compliance with the terms of the trust. Okay, so thanks for that, B. We have now the flowchart. These flowcharts are very good. I didn't prepare them. They came with the course, but I think they're really useful. And you'll see here that in the context of express trust, we have the reference to the 3 certainties. We have issues to do with the types of trusts on the left-hand side, issues to do with the validity through the 3 certainties, intention, subject, and object, and issues to do with rules against perpetuities and certainty of subject. So I'd recommend that you follow that to give you some idea of some structure, further structure to this process. Okay, so we mentioned that beneficiaries don't necessarily have a right to compel the trustees to provide funds to them, but beneficiaries can, as B said, use Section 8 to seek an order of the court. What sort of orders can a beneficiary seek from a court where there is an allegation of a breach of trust? Now, bearing in mind, trust is closely aligned with equity, so there's a big hint.
Where they've given benefits to themselves or they have conflict of interest?
Yes, but of course I'll reword my question because I'm looking for a particular thing. Without necessarily identifying the nature of the claim that's being sought, what type of remedy, what type of order can beneficiaries ask the court to give them when making a claim, an application under Section 8? Restitution, yes. Even more broad than
Could
that.
they ask for compensation?
Yes, equitable compensation. Yes, compensation. Remember, that can be account. B says an account of profits. These are all good answers. They're not the answers I was looking for.
Could they ask for an injunction?
Injunction.
Injunction, that's the one I'm after. And B said tracing, Sophie said latches. Yeah, look, I just, when you're making an application to a court seeking an equitable remedy, then yes, by all means, you can do those other things that are more long-term, but the immediate things that you might be seeking are an injunction, which is, of course, an equitable remedy, or a declaration, which is also an equitable remedy. So they're really two quick things that you might consider in terms of an application. And applications are much easier to initiate and dispose of than proceeding by way of a claim. So just keep that in mind, applications, particularly for Section 8 injunctions and declarations. A declaration is simply the court saying, well, here is the legal position relevant to your matter. They're not actually forcing anyone to do anything, as opposed to injunctions. But a declaration is, having obtained the benefit of a declaration, it would be a brave party not to comply with the what it is that the court has said is the law in that situation. Now, someone said tracing. What's tracing? And we've just another 5 minutes. So what's tracing?
You can trace the profits illegally, well, again, wrongly obtained profits. Like he sold the trust property. So now you can, trace the amount of money he got.
No, I agree with that. And my next question is an action in tracing personal or proprietary? And Brad's already answered the question, so if you look at the chat facility, you'll see the answer.
With tracing though, is there an issue that once the waters have kind of been muddied and it's mixed up with something else or been changed to something else, you can no longer have that remedy of tracing? Is that right?
No, not necessarily can't have the remedy, but it certainly makes it much more difficult. And tracing is really going to be very difficult where you've got a bona fide purchaser of property without notice. So there are a whole lot of rules that apply to tracing, but it is essentially a proprietary remedy that's available in both law and equity. And it is possible, Angela, to trace assets which are mixed. Legal tracing is possible until it's mixed or destroyed. Equitable can follow even if it is mixed or consumed. A couple of cases to look at there. For legal tracing, it's Puma Australia against Sportsman Australia, 1994 to Queensland Reports at 159. And equitable tracing, have a look at Brady and Stapleton, 1952, 88, CLR 322. Now, Linda says, could you explain mixed property as at 5.9 of the notes? I don't have my notes here, but when we talk about mixed property, we're talking about something which has been incorporated into something else or mixed with something else. So to give an example, if you're trying to trace an engine, a motor vehicle engine, if that motor vehicle engine has now been put into a motor car owned by another party, it has become mixed with that motor vehicle. So it's where the property becomes part of something else or is mixed in with something else. And Tamara says, Brady and Stapleton, what's the reference? Sorry, 1952, 88 CLR 322. The other case was Puma, as in Puma Sports, Puma Australia against Sportsman Australia. And that was 1994 to QDR 159, QDR being Queensland. All right, so just be aware of the difference between an equitable remedy, which involves a personal remedy, or a proprietary remedy. And as we discussed, a remedy that's personal in nature is simply enforceable against the person who's liable. It doesn't attach to property or create an interest in property. So a plaintiff claiming a personal remedy gains no priority above other creditors if the defendant becomes insolvent. So, but if you have a proprietary remedy, then you can claim a priority over other creditors in a liquidation situation. So it can have a very practical effect whether you're chasing a personal or a proprietary remedy. All right, we're 1 minute to go. I'm just going to ask for this. Can you give me an example of a personal remedy, and can you give me an example of a proprietary remedy? We've talked about, I think, all of these just about tonight. What's an example of a personal remedy? Compensation, yes. Compensation is a personal remedy. And that makes sense because, as I think Linda said, we're chasing money, not property, so compensation. Account of profits. Yeah, thank you, Grant. That's the other personal remedy that I had in mind. Okay, examples of proprietary remedies. We talked about one of them in particular a bit tonight. Constructive trust. Yes, that's very good. We didn't talk so much about that. What was it? Tracing. There it is. Tracing. Oh, you're all coming in with tracing. You've got that nailed. We know tracing is a proprietary remedy. And that makes sense because we're actually chasing some property, proprietary. Okay, any questions before we wrap up? Thank you for your patience tonight. Thank you for your good work. Yes, Brad?
Just a quick one. It just in 4.9 talked about compensation for negligence, unauthorised early sale of an appreciating asset. Would the key word there be unauthorised? Because to assume something's going to appreciate, I mean, you know, if I knew what shares were going to go up next month, well, they're the ones I'd be buying, so I wouldn't be selling them. So I'm assuming that the key word there is the act of it being unauthorised.
I think you're spot on.
Not so
Brad.
much it being an appreciating asset. Okay.
Yeah.
Thank you.
No, I think that's
when I read
on.
that, it was like, how do you know?
Oh, yeah. No,
John, I just got a quick question.
yes, Peter.
Just getting prepared for the exams, I just want to make sure I get any material that I may need to get printed off. Trusts Act, would we need the Family Law Act?
No, only those sections that we talked about tonight, really. 79, 75.
Right, yeah. Would there be any other acts that?
Or maybe
would there
just
be any other acts that may be recommended?
I mean, tonight we've talked about Social Security Act and we've talked about UCPR. We've also mentioned Property Law Act. Look, I don't think so. I think probably of those pieces of legislation, if at all, you could be very selective.
Thanks,
I hope that
John.
answers your question. And just remember, keep answering those weekly problems. We're not talking about them specifically, but we're talking about them generally. But you know that they're going to be close to the exams. All right, I'll end the meeting now. Thank you. And those of us in evidence, we'll see you soon. Okay, all the best. Bye.